Thank you everyone for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we're going to spend some time to discuss the E-2 visa requirements and considerations for renewal of the E-2 visa. So just going over a few things before we get started. Some of you may know that the firm Scott Legal was actually founded on an E-2 visa 10 years ago, and the founder of the firm applied for an E-2 visa actually to come to the United States to establish Scott Legal. And the firm has successfully renewed its E-2 visa as well. So this definitely gives us very deep familiarity and expertise with E-2 visas, and we have processed thousands of E-2 visas. Now, Scott Legal is a full-service immigration law firm, but we do focus primarily on E-2 visas. We have processed hundreds of them, and we process many E-2 visas that are considered higher risk, which means with a relatively lower investment amounts for smaller businesses. And we have processed E-2 visas at many different consulates around the world, but our primary two consulates are Toronto and London, and we have very deep familiarity with those consulates. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. So first, we will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive guide to the E-2 visa that you can use as a resource. We will also send you a link that you can follow to sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we do regularly upload a variety of immigration law related videos that can be helpful to you. Finally, we'll send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. As for today's panelists, we're very lucky to have Kelly Weiner, who is a partner of the firm, who has a wealth of expertise in processing a wide variety of E-2 visa cases, and will be sharing her insights with you all. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will start the presentation. So let's start with the E-2 visa requirements. What are the E-2 visa requirements? How can you qualify for an E-2 visa? So just as an overview, as many of you may know, the E-2 visa is a visa for entrepreneurs. And the E-2 visa is a non-immigrant visa for investors who are seeking to come to the United States to develop and direct a U.S. enterprise that they invested in. So when we say it's a non-immigrant visa, it means it is not a green card. But it is important to note that an E-2 visa holder can continue extending the E-2 visa indefinitely as long as the applicant continues to meet the E-2 visa requirements. Now, you can qualify for an E-2 visa either through purchasing an existing business in the United States or setting up a new enterprise in the United States. So, to be eligible for the E-2 visa, you must meet certain requirements, and they're listed here. So the first requirement is that the applicant must be a national of a treaty country. And what does treaty country mean? So the E-2 visa is an option available for nationals of over 80 countries in the world that have signed an economic treaty with the United States that gives them the option to use the E-2 visa. And this does include many countries around the world in all continents. And this includes, for example, Canada, Mexico, the UK, New Zealand, Singapore, Jamaica, Philippines, etc. There is a wide variety of countries that participate. Now, it is not available to nationals of certain countries that have not signed such an economic treaty with the United States. And common examples of non-E2 countries are India, China, and Russia, which are countries that do not participate in the E2 visa program. However, it is worth noting that if you are a dual national of a non-treaty country and a treaty country, you can still use the treaty country's passport to apply for the E2 visa. So that remains an option for you. So it is worth pointing out here that nationality in the E2 visa context means having a passport of that country. So treaty country nationality does not depend on the country of birth, unlike in other visa contexts, green card contexts. A dual national of Canada and a non-treaty country, for example, can use their Canadian passport to qualify for the E-2 visa. So if you would like to see if your particular country of nationality participates in the E-2 visa program, you can go on Google and search for Treaty Countries Department of State, and you will be able to see a list of the participating countries. And this list definitely does get updated from time to time, so definitely look at the most recent list that is up there. The other requirement for an E2 visa is that the E2 company must be at least 50% owned by nationals of the treaty country. And when we say E2 company, we mean the enterprise that it is being purchased or being set up in the United States. The ownership requirement is at least 50%, and this includes 50%. So 50% or more ownership by nationals of the treaty country. And this also goes to the requirement that the applicant is coming in to develop and direct the enterprise. So having 50% ownership gives you that control over how the enterprise is being managed. So that goes directly to that requirement as well. The other important requirement to keep note of is that the applicant must make a substantial investment in that enterprise to qualify for the E2 visa. And let's kind of break down what making an investment really means. So an important thing to note is that the funds being invested must be at risk. And a common question that we get is this. If someone has, let's say $100,000 in their personal bank account, and let's say they set up their own LLC in the United States, and then what they do is they move the $100,000 in their personal bank account to the business bank account and say, okay, I've transferred the funds. Now the funds are sitting in the LLC's bank account. I've finished making my investment. And can I qualify for the E2 visa? And the answer to that is unfortunately no, because in order to qualify as an E2 investment, the funds must actually be at risk of loss. And if you only place the funds in a business bank account that you own, that your LLC owns, and you own the LLC, then practically there is nothing that prevents you from just taking the money back into your account. So what the consulate wants to see, for example, in the startup context, is that most of these funds have already been spent on tangible things that show the applicant's commitment to running the enterprise. So for example, if you already signed a business office lease, and you've paid, the security deposit and the rent for such an office space. If you've already hired an employee and have started paying the employee's wages, things like that are things that are spent on tangible things that really show the applicant's commitment on running the enterprise. And those are money that has actually been spent, which is that it is subject to risk of loss. So for example, if you're not granted the E2 visa, and if you cannot run the enterprise, these funds would, not be there anymore. So that is what we mean when we say the government is looking for funds actually placed at risk. If you're purchasing a business, on the other hand, there is one option you can use to hedge against the risk of potentially, if the E2 visa is denied, for example, right? And that is using an escrow account when you're doing a purchase of a business. So you can arrange with the seller to use a third-party escrow account where you can put the purchase funds, and as long as the sole condition of the release of the funds from the escrow is that the E2 visa is approved. So if there are other conditions to the sale being consummated, that may also pose challenges on meeting the at-risk requirement, right? So the only exception that we see here is that if, the escrow funds will be released on the sole condition of the E2 visa approval. So otherwise, so generally speaking, you definitely want to make sure that you've placed enough funds at risk to meet the requirement for substantial investment. Now, the other part of a substantial investment is that the investment amount must be substantial. And so how much money does the government think is really substantial for a business? So we will go into more detail on the next following slides, but there is no hard and fast minimum that is required under the regulations or law. But really, the question depends on the type of business being started and being, managed, and also the nature of the investment. And the other part of making a substantial investment is that you also need to clarify where the funds came from. So that's what we call the source of funds requirement. And the government is looking for any legitimate source for the business. And this can include a wide variety of sources of funds, such as saved earnings from employment. It can, be a gift from someone or, and a loan, for example. And the only thing about the loan is that the loan cannot be secured by the E2 business or the E2 business's assets. And the loan can be an unsecured loan, or the loan can be secured by other personal assets like your residential house. But the requirement is that it cannot be secured by either the E2 business or the E2 business's assets. And the other thing, if you're using, a personal gift or a personal loan for a source of funds, the other thing you want to think about is that you also need to go one step further and clarify where the gifter or the loaner got their money from. So the source of funds inquiry actually extends there. For example, if you received a gift from, someone and that person, earned that money from employment income, we would want to, provide the income tax returns of that person who gifted you the money to show where, the funds came from. Similarly, if you received a personal loan from someone and the person, let's say, obtained those funds from a sale of a house, for example, we would need to go and, provide the evidence of the sale of the house, for example, to show that those funds were indeed earned in a legitimate manner, as the government likes to see. So let's go through the other requirements for E2 eligibility. The business must be real and operating. So what that means is either the business, must already be active, having clients, taking revenue, or that it is really close and ready to start running, hit the ground running once the visa is granted, right? So this really means that everything that is necessary for the business to open its doors must already be secured by the time you apply for the visa. So, for example, the business entity in the US must already been established, right? The incorporation or LLC. If the business, has an office space, the lease for the office space must already been executed. Any required licenses must already have been secured if the business requires a license to operate in that particular field. If this is a company that provides services to clients, and if you already have client contracts to provide services, that can be very helpful in meeting the real and operating requirement. So what the government likes to see is that everything that is necessary for the business to open its doors have already been secured, such that it is, in fact, a real and operating business, and that as soon as you're granted the visa, you'll be able to start running the business in the United States. So hire U.S. workers. That is another requirement for qualification for an E2 visa. The E2 visa is not a visa that is for, someone who wants to be a sole practitioner, for example, right? Like a one-person business. And this goes to the marginality requirement. And when we speak of marginality, it means when the government is, evaluating a case for an E2 visa, they're looking for a business that will generate more income, a greater amount of income and profits than what is required to simply support the investor themselves or their family. And this is called a non-marginal income. And this is most commonly proven by showing that the business will have potential and will hire multiple U.S. workers to support the business operations. So we do need to provide enough information to the government that will convince them that this is going to be, more than just a one-person enterprise. So that is definitely an important consideration when you're thinking of the scale of your business. So the final requirement is that the E-2 visa is a non-immigrant visa, which means the applicant must be able to present an intent to return to their home country if and when the E-2 visa status is terminated. And this is usually satisfied by providing a signed statement of the applicant to that effect. That they do intend, to return to the home country after the business itself is over. All right, so options and timing for obtaining an E-2 visa. So as I mentioned briefly in the earlier slide, there are two options when you're thinking of getting an E-2 visa. The first option is starting your own business in the United States, and the second option is purchasing an existing business in the United States. And the escrow considerations, when we speak of escrow considerations, that's one option that you may have to hedge against the risk of potentially, if the E-2 visa, in the rare case the E-2 visa is denied, if you use an escrow account for the purchase, and if the sole condition for the release of the funds in escrow is the approval of the E-2 visa, that can still meet the requirement for the investment to have the funds be at risk. So that is an option that you can consider using when you're purchasing a business. However, if you're starting a business in the United States, you do need to make, tangible purchases that will, meet the requirement that you have placed enough funds at risk. There is no, parallel to the escrow when you're actually setting up a new business. For how long is my E-2 visa valid? So this definitely depends. And the first element to consider is the country of the visa issuance. So the validity of your E-2 visa will depend on your country of nationality. And you can look this up by Googling reciprocity schedule, Department of State, and you'll be able to click through your country and click through the E-2 visa, and you will see the options available there. For many countries, the visa can be valid for up to 5 years. For certain countries, and this is a rare case, the visa validity period can be as short as 3 months. So this definitely depends on the country of nationality. Now, one thing to note is that the length of an E-2 visa is a different concept from the length of an E-2 status, which is granted for 2 years at each entry. So let's unpack that a little bit. So when we speak of visa validity, we speak of the length of time during which you're able to travel to the US. So a way to think about this is that the visa is kind of a ticket where, you present at the border to obtain admission on E-2 status. However, this is different from the length of the actual E-2 status you are given at every entry, which is how long are you allowed to stay once you enter the United States on E-2 status. And that is depends on your I-94. So your I-94, which is given to you at each entry, determines how long you're able to stay in the US on E-2 status, which is 2 years for every entry. So let's go back to the example of the E-2 visa being valid for 3 months. So what this means is within the 3 months validity period of the visa, you will, apply for admission at the port of entry to be admitted to the United States on E-2 status. But once you're granted the E-2 status and actually admitted to the United States, you have 2 years to develop and direct your business. So definitely keep in mind the distinction of, the visa being valid for a particular period of time and the actual length of stay that you're given at the port of entry, which is 2 years. So even if you have a 5-year length visa, for example, right? When you're coming in on the visa, and if you're admitted on E-2 status, you'll be given 2 years to stay in the United States and develop and direct your business. And at the end of the 2 years, you should plan to, make an exit and entry to, kind of get a new period of entry with a new I-94. And I guess you can also, extend your status in particular circumstances, but definitely speak to your lawyer with the options that you have. It is very important to always keep track of what is the I-94 expiry date, which is what governs the length of your authorized stay. So consular officer decision, that is another thing that can impact how long your E-2 visa is granted for. So even if your country of nationality has a particular length that is standard for that visa category. So, for example, if you're a Canadian national, you could get up to 5 years of your E-2 visa. If a consular officer looks at your case and thinks, it's maybe a little bit of a borderline case, and they want to see you, come again to renew the visa because they want to really see that the enterprise has hired employees or something like that, then they do have the discretion to issue the visa for a shorter period of time. So even if, the maximum is 5 years, you may, after an interview, the consular officer may make a decision to issue the visa for, I don't know, 2 years, like a shorter period than that, depending on the case circumstances. So that is definitely something that can also impact the visa validity duration. All right. So now let's shift gears and talk about the amount of investment that is usually needed for a qualification for an E-2 visa. Now, as I mentioned before, there is no hard and fast minimum that is set in the regulations or the law of a dollar amount. However, the applicant must convince the officer that they have invested a substantial amount of money. And so what does it mean to have invested a substantial amount of money? So really depends on the type of business that is being started, right? So let's say if you're proposing to start an office type consulting business, a service-based business, this can typically require a lower amount as an industry standard. For example, 80,000, 100,000. If there are not as many, upfront high costs to start that kind of business. So maybe you need a lease, maybe you need some computer equipment, maybe you need some furniture for the office. But that kind of service-oriented business may require less startup costs than are usually required for a different type of business. Let's talk about things like a restaurant, right? A manufacturing company or a retail store, for example. Those types of businesses, as an industry standard, would typically require a higher amount. Maybe the business would require more expensive equipment, more expensive machinery. Maybe you would require a larger space to warehouse the inventory, etc. So if you're proposing to start that kind of business, the government will definitely want to see a higher amount of money to find that the investment has been substantial. So what the government uses when they're looking at the substantiality of an investment is what is called a proportionality test. And so what that means is the smaller the total costs needed to set up or purchase a business, the higher proportion of these costs must already been spent. So for example, for smaller companies that requires like anything less than, like 400K, 300K to set up or purchase, the government will expect the applicant would have spent 100% of those kinds of funds required. By contrast, if it's a 10 million, enterprise that the applicant is applying for, then even if, the applicant has put, 1 million towards, investing in that business and is only 10% of the total cost required, that will likely still be considered a substantial investment just because, the total cost of setting up that kind of business is so high. When the applicant is buying a business, the inquiry is a little different with regards to substantiality. When the applicant has bought a business, the officer would compare the cost of buying the business, compare the cost of what the applicant paid to buy the business versus the fair market value of the business itself. So if you bought the business in the open market, right, you likely did pay the fair market value by definition, and that would likely be considered a substantial investment. Now, by contrast, if you purchase the business through a closed market transaction, so through someone you know or through, a friend, for example, that would pose more questions on that regard. So you may need to do a little bit more research on what the fair market value of that business is to meet the substantiality requirement. And this may it may be helpful for you to get an independent opinion from a CPA, for example, that can look at the financials of the business and provide an opinion letter of whether the purchase price matches the fair value, fair market value of the business. So that's how the substantiality requirement will be assessed in that context. So I forgot to mention that substantiality also depends on where you apply and the examiner. So when we say where you apply, it means different consulates around the world have different standards, kind of, as a matter of practice on how much dollar value of the investment they expect to see to qualify as substantial. So when you're applying for applying for an E-2 visa at a particular consulate, definitely speak to your attorney first because our advice on how much to invest will differ based on where you're trying to apply. So definitely reach out to us. We'll be happy to provide some guidances. Um, franchises. Franchises can be a good option for E-2 visas. Especially because any costs that you pay to obtain the franchise rights can also be used, towards the investment amount. So it can be, a good way to, present a substantial investment. It can also be a good option because franchises tend to provide support in terms of, how to market your business, kind of operational manuals and things like that. And some franchises are quite famous, so you can also benefit from the goodwill. So it can also help, providing a good case for marginality and real and operating because franchises will help you kind of hit the ground running, so to speak, when you purchase that kind of support. So that can be definitely a good option for E-2 visas for in multiple ways. Common, good, and bad E-2 visa expenditures. So not when you're setting up a new enterprise to qualify for the E-2 visa, not all expenditures have similar, helpfulness and strength for, qualifying as an investment. So, for example, when we speak of good E-2 visa expenditures, we want to focus on typical expenditures that can be considered as legitimate investments for business setup. So things like purchasing a lease for a business office space. And any rent that you have paid, and even rent that you pay upfront, right? Prepaying some rent can also, be helpful when you're trying to increase your investment amount. Things like equipment that is necessary for a business. So if you're a service-oriented business and you purchase computer equipment to use for your business, that is definitely a legitimate expense that you can, count as an investment. Things like marketing and advertising costs for, setting up that pipeline to get clients for a business. That is definitely an example of a legitimate investment. Any licensing fees, if licenses are required for your business, any costs that you incur in setting up employee payroll, and any, payments that you did make to employees, that can also be included as part of legitimate startup investment. Any, professional services that you use to, set up your business, such as if you hire an accountant to set up your account, things like that, you can include as legitimate investments for a business setup. Even, legal services fees, right? So, costs that you incur, hiring lawyers to help with any aspect of business setup, and even to apply for the E-2 visa, you can include as part of your E-2 visa expenditure. Now, things that are on the weaker side are expenses that may not appear at first glance to directly relate to the business. So for example, like things like, travel related expenses. If you, purchase airfare to come to the United States to look at potential businesses to set up or purchase. Any airfare travel related expenses we would not recommend including as an investment for business setup. And in a similar vein, things like client meals and entertainment costs, expenses like that, we would typically not recommend including any expenses that will be directly reimbursed by a client or customer. That would also not be recommended to include. Um, Vehicle can work in certain circumstances, but not in other circumstances. So if you're purchasing a vehicle and if there is a really legitimate business need, right, for that vehicle to transport equipment or personnel, so if it's, really required for a business, like if it's a landscaping business, for example, having a company vehicle definitely makes sense. But purchasing a vehicle in other contexts, such as if it's a service-based company and you're just purchasing the vehicle to, go to and fro from work, from your office, that would likely not be recommended to include as part of your investment. So definitely. It is worth, working with a lawyer, and, we are happy to review, your expenses and advise on which types of expenses will be beneficial to include and which one should be better to be left out in the investment amount. All right. So the other common question that we get regarding the E-2 visa is that, do I have to hire US employees? And the answer to that question is definitely yes. And the reason why is that we need to always prove that the E-2 business must have either the present or future capacity to generate enough income to provide more than a minimal living for the E-2 visa applicant and their family. And this most straightforwardly means hiring US workers. So we recommend that the applicant be able to prove that the business will hire at least 3 to 5 US full-time employees over 5 years of running the business. And it is okay if, for example, if you're applying for a brand new E-2 visa for a startup, it's okay if you don't have any employees at the time you're applying for the visa. But the officer must be satisfied that the business will have enough potential to hire that amount of employees in the future within the 5 years of operations. So there definitely needs to be a convincing business plan to scale up to that point. W-2 employees versus 1099 workers, that's one distinction that we can make. Generally speaking, hiring full-time W-2 employees is the preferred way to hire US employees to meet the marginality requirement for the E-2 visa. 1099 workers can be relevant, especially if you're working in an industry that typically hires 1099 workers. So, for example, if you're operating a cafe and if you hire, like 12 different 1099 workers who come in to do part-time gigs, and if that's the, industry standard for that particular field, that can work. However, generally speaking, having W-2 employees is recommended and is preferable in the E-2 visa context. So with regards to the requirement to hire US employees, how can you prove that you have hired US employees or that your business has the potential to hire US employees? If it is a new business that you're applying for the E-2 visa with, a business plan is a very important element of proving this potential. And in the next slides, Kelly will go over what specifically to include in this business plan. But generally, it must provide a detailed and convincing financial picture of the profit, expenses, and the losses, and a detailed table of the projected hires over the next 5 years that can show, how the business is attempting to scale up after the E-2 visa is approved. Letters of intent from clients can definitely also help with marginality. Letters of intent mean, you know, potential clients that that intends to hire the business's services once the business is operational in the United States. If you have, if you already have contracts for such services, and if you can bring those contracts to the interview, that could also be very helpful in showing that there is actual demand in the United States for the business's offerings. that can be very helpful to meet the marginality requirement, even if you don't have employees at this particular point. For existing businesses, and this is also relevant for renewals, very important elements are the W-2s that a business files at the end of the year. You want to show that the business has had a history of hiring workers, especially when you need to renew your E-2 visa. Pay stubs is also important, such as a payroll summary that lists out how many employees you have under the business at a given period of time. That is also a very important element for an E-2 renewal, in showing that you did hire U.S. employees. Tax returns is also a very important element for E-2 renewals. You want to be able to show that the revenues earned by the E2 enterprise is of a scale that is more than marginal. And more than marginal means that it is, higher than what is normally expected for one person to, earn for, supporting themselves and their family, right? So you want to make sure that the revenues that are reported in the company tax returns are of that significance, of a sufficient amount that will sufficiently meet, the marginality requirement. All right, so now I will turn it over to Kelly, and she will take us through some other considerations regarding the E2 visa.
Thank you, Jiyae. So we're going to talk a little bit about what the business plan should contain. And it's very important for kind of E2 startup cases to have a comprehensive business plan. You want to start with an executive summary. So who are you? What do you do? What do you sell? Officers are often reading these very quickly, skimming them. So you want to make it as easy as possible for them to understand what the business does. You also want to provide kind of some market analysis and research to show that there is a target market, and that you understand what that market is. You should also have a marketing plan that says here's how we're going to get clients. Most companies are going to need something like a website, and then there's kind of a variety of other things that should be customized to kind of your particular type of business. But that's a very important thing. They do want to see how are you going to get clients and customers, particularly if you're in kind of an industry that's very saturated. Like if you're a consultant, they want to understand, why are people going to choose you, among all of the consultancies out there. A personnel plan is also very important to show that you meet the marginality requirements. So this would be kind of 5 years of hiring projections, and this should include things like job titles, job duties, and kind of planned salaries and raises over 5 years. The salaries should also make sense in light of the type of job you are hiring for. So, if you're hiring for kind of a CFO level job and you're paying minimum wage, that's not going to look, logical. You want to take that into account and make sure that when you're creating your hiring projections that they are realistic and reasonable. Also, you'll have to have a comprehensive financial plan. So these are kind of 5 years of financial projections, a balance sheet, an income statement, and a cash flow statement. This is very important just to show the officer that you have kind of a reasonable plan for kind of making sure that the company is going to earn money. You also want to have kind of a common sense, written explanation for the revenue assumptions. And you want to be able to describe those, if you're either submitting for a change of status to U.S. Citizenship and Immigration Services, they sometimes will come back and say, please explain this. Why is this reasonable? If you're going to a consulate and you're going to go to an interview, the officer may ask you, why are these, realistic projections? You don't want to say, oh, my business plan writer said that this would work. They expect that you, as the business owner, will understand, how am I going to make this money? For example, if it's a consultancy, are we doing billable hours? How many people am I hiring? You don't need to kind of go into a bunch of granular detail necessarily, but you do want to know the officer will not necessarily understand your industry, and you want to be providing an explanation that they can understand as to how you will make this money. All right, so let's talk about some E2 visa considerations. Big question, should I apply with USCIS using a change of status? or should I go to a consulate and get a visa stamp? And there's kind of different considerations to take into account. So, one, you're only eligible to do a change of status if you are in the US in a valid status that allows for this. So let's say you've entered on ESTA, just to investigate some businesses you might want to buy. You are not eligible to change status. So a change of status with USCIS is not available to you while you are on ESTA. Let's say you've entered with an actual B1, visa stamp in your passport, then you may be able to apply for a change of status. Or let's say you're on an H-1B and, you're interested in switching from your H-1B employment to, running your own company. In that case, if you're in the U.S. in that valid status, you will be able to potentially change status. A benefit of changing status is one, you don't have to leave the United States. So it can kind of all done on the paperwork from within the US. You also can pay an additional fee to get a response within 15 business days. That's an approval, denial, or request for more evidence. Um, Additionally, they are sometimes friendlier to lower investment amounts. So, for example, if it makes sense in light of the business, if you have like a really, low cost like service business, we've had cases sometimes even with investments as low as maybe $30,000, $40,000, which is extremely low. Most consulates will not entertain, a case with investments that low, but USCIS does seem to be more amenable to it. That being said, they are also much stricter on the source and trail of funds than they are at consulates. So if you have a very complex source and trail of funds, maybe it's money that you have from years and years ago and you don't have a clear trail, or it went through multiple bank accounts, or it's from multiple people who won't give you documents, that's not going to be a good case for a change of status because they will require exactly where the money came from. Even if you say it's my savings from employment, they're going to want to see your tax returns. They're going to want to see your pay stubs. They're going to want to see your bank statements with the pay stub, money going into the bank account and being maintained there. If it was then transferred to other places, you will have to track that trail. So if it's like let's say you sold the property, you got the money in your bank account, a week ago, and now you want to use that for your investment. That's very straightforward. You'll be able to trace that. But if it's something more complex than that, a change of status can be very complicated. Another downside of a change of status with USCIS is that you will not get a visa stamp that allows for international travel. What you will get is a 2-year approval notice that allows you to remain in the United States and run your company. But let's say after 1 year, there's some emergency back home, you have to leave the United States. Now, when you leave, you cannot get back in on the basis of that approval notice. And you also cannot take that approval notice to a consulate and rely on it to get a new approval. You will need to submit a brand new application at a consulate and get a visa stamp before you can re-enter the US. And the consulate does not have to rely on that USCIS approval. They will adjudicate it as a brand new case. So for people who need to travel a lot, a USCIS filing may not be the right option. Consular filings can be very attractive for that. There's many people that can get multi-year visas. I know Jiyae talked about reciprocity schedules. So, for example, if you're from Canada, if you're from the UK, you can get a 5-year visa stamp. Every time you enter the US, you'll get 2 years in E-2 status. But when that 2 years is up, you just travel back in and out on your valid visa. It means you don't have to kind of go back and present a case for renewal so quickly. Whereas if you're doing a change of status, when that 2 years is up, you have to present a case for renewal showing how the business has been doing. And for some companies, it takes longer than that to really kind of ramp up operations and be successful. Moving to another thing on the list, source and trail of funds, we kind of just talked about this. Again, for a USCIS filing, you really need to have all that documentation. Loans secured by company assets. So this is not permitted as a source of funds for the E-2. So, if this comes up sometimes in seller financing situations where maybe you want to put down 50% of the money and then 50% is seller financing where the security is, the assets of the E-2 company. That is not going to work well for an E-2 case because anything that is secured by the assets of the company is not considered to be your personal assets at risk. If you do have a loan, it should either be an unsecured personal loan in your name, not the company's name, or it can be a loan secured by your personal assets. Let's say you took out a home equity loan. a second mortgage. Those things can work, for the E2. You can also get a gift. However, with a gift, you want to make sure beforehand that the gift giver is willing to provide you with all the documentation to prove where they got the money. So let's say your mom is giving you a gift. She cannot just write you a gift letter. She also has to prove where she got the money. So if she sold the property, we need to provide that purchase sale agreement and the proof of her getting the money and sending it to you. If it's earnings from employment, we need to see her tax return. So you need to make sure the gift giver is comfortable giving you, kind of that sensitive information. Uh, so considerations for a small investment amount, letters of intent showing you're going to have clients right away and cash flow right away. That can be very compelling. You can also ask a CPA, maybe specifically one who works in your industry, to write a letter, look at your business plan and your investment and explain why this is a reasonable, investment for this type of business. People will also ask, can you get E2 visas for two investors? And the answer is yes, but it has to be a 50-50 ownership split, for two investors. Substantive changes to the business after filing. It's an important thing to keep in mind that just because you get a 2-year, 3-year, 5-year visa, in order to kind of continue to maintain that visa and have it be a valid travel document, you do need to continue to run the business that you presented to the consulate. So if you shut down your LLC and start running a completely different business, you have now violated your status. Your visa gives you the ability to run the business that you presented at the consulate. If there are kind of minor changes to the business, changes contemplated in the business plan, natural outgrowths of change, like you said, you were going to be consulting for mostly finance people, but it turns out you're mostly consulting for people in the entertainment industry, but you're doing the same type of consulting. This is not an issue. But if you are doing a wedding photography business and you want to shut that down and run a restaurant, that's going to be considered a substantive change. You will need to go back to USCIS or the consulate and get an approval before you can proceed with that change. Um, when you're doing an E2, there are some higher risk cases. So one would be real estate. Very common misconception that you can buy a property, put it in the name of an LLC, and get an E2 visa. So they're very sensitive to that. They're going to want to see, if you are kind of, buying and selling homes, if you're flipping homes, they're going to want to see a very large portfolio, very large investment amount. If you're doing kind of property management, they're not going to want to see, well, I own 2 Airbnb properties. That's not going to be active enough. You really need to show that the business is going to be active enough to employ people in the United States, and not just kind of be passive real estate holdings where you're just collecting rental income. Equity trading, kind of sometimes similar concerns to real estate, very highly regulated industry. People sometimes will just feel like they can trade their personal stock portfolio. That's not going to be active enough. Again, you do need to be able to explain how this will be a real and operating business and large enough to kind of sustain the investor and hire workers in the United States. Family business purchases. So if you are purchasing a business, generally they will consider kind of the fair market value of that business to be a substantial investment. However, if you're purchasing from your brother, they will have more questions. They want to know, is this really the fair market value of the business? It can be good to get a valuation from an objective third party, CPA, evaluation company. At the very least, the purchase price should make sense in light of the financials you're seeing for the business. So if it's a business with a lot of assets, a lot of profit, and the purchase price is very low, they're going to look at that, and have questions about that. So you want to have an explanation for how you came up with that purchase price. Okay, let's talk about common reasons for E2 denials. So one would be kind of low investment amount. There's kind of, different places that, will contemplate, different levels of investment. There's some consulates that really want higher investments. Some like USCIS are friendlier towards low investment amounts. That being said, there's some investments that are just too low. We had a client one time who applied on their own, spent $2,000 and put $98,000 in a business bank account. It's just too low. We were able to advise this person on spending more. They ended up spending around 50,000 and ultimately were approved. So if you are denied for low investment amount, one potential, upside is that if you do have more money to invest, relatively easy fix. Nature of the business. So we just talked about this. There are some, industries that are going to be very high risk. If you do have kind of an option about which industry you want to enter, you may want to stay away from some of those more high risk ones. So filing location and venue, we've discussed this a bit. For example, USCIS is more friendly to lower investment amounts. There are some consulates that are mostly used to seeing huge companies that are sending over mostly E-2 employees and investing millions of dollars. Those consulates can tend to be, less friendly to the smaller investor who might be investing 60, 70, $80,000. So you do want to talk to your attorney. These are trends that change over time as consular officers change over time and politics change over time. So this is something to discuss with your attorney at the time you're filing because it can change. So the next two are kind of related to marginality. Did you run a business in your home country where you did not have any employees? So let's say you ran a solo consulting firm for 10 years and now you want to come do the same thing in the US. They may not believe on the strength of a business plan that you're really going to hire someone because you spent 10 years operating as a solo consultant. So this is this concern about will you create jobs for US workers? In this instance, if you have this kind of situation, you may want to hire somebody before you file your petition. It's not required, but it could really help your case and kind of mitigate that concern with the officer right away. So they won't say, well, we don't believe you're going to hire someone. You can show I've already hired someone. I paid them, they're kind of maybe an office assistant helping with admin as I get things going. Um, Issues with the adjudicating officer. So officers are human beings. They have different levels of training. There are times where they take different approaches based on what's happening at the consulate. If you do feel like the officer is really off base or, really, kind of inappropriate, you do want to kind of after the interview, write down everything that happened, the questions they asked, the answers that you gave, so you can see what type of remedy you might have. They do have complete discretion over whether to approve or deny the case. So you do want to be as polite as possible, even if they are not. And if you do reapply, they usually will try to give you a different officer. Another reason for denial might be you didn't meet the requirements at the time of filing. So let's say you file a case, but the entire thing is a loan secured by the assets of the E-2 company, or the company is only 20% owned by treaty country nationals and not controlled by them. At that point, you got to go back to the drawing board, kind of discuss with an attorney who specializes in these types of visas and kind of try to resubmit once you meet those requirements. Okay, what does it take to renew an E-2 visa? So many consulates, what they're really going to ask for are your tax returns, your financial statements, and your W-2s. So they want to see, did you hire U.S. workers? We generally recommend that a business hire at least 3 to 5 full-time employees by 5 years. That being said, we've had many cases where there have been approvals with less than that. Sometimes you can explain, hey, we did actually hire like 8 people over the course of these past 5 years, but just due to employee attrition and issues within the markets, we currently have 2 employees. So there are things that you can do, but if you've reached, year 4 and you haven't hired anybody, this is going to make for a difficult renewal. Or, you have one part-time person who works 5 hours a week. These are going to be difficult cases to get renewed. Uh, Many times they'll ask for tax returns for the past 2 years. Sometimes they ask for tax returns for every year since you filed. So if you had a 5-year visa, you might have to produce 5 years of tax returns. You want to focus on, is the company profitable? Any benefits. Any kind of accolades the company has gotten. If it's the type of company that gets reviews, you could provide that. If you've made additional investments that have, been positive for the company, you can explain that. Also important to show that the company still meets the E-2 requirements. So any changes to ownership can be problematic. Let's say you had the type of company where you wanted to kind of sell shares and you have now dropped to 30% ownership. If the company is not controlled by you and no longer 50% owned by treaty country nationals, this can be a major problem. So if you are in a case like this and you're considering your ownership changing, always discuss with your attorney before you make any ownership changes. Also changes to the type of business, which we've discussed previously, major changes need to be approved before you can go ahead with that new type of business. Okay, so developments and adjudication trends. Um, E-2s have high approval rates, currently 80 to 90% as posted by the government. In the last administration, it was kind of similar. These approval rates didn't change that much. That's not to say they won't change this time, but this is what they currently are. We anticipate a focus on kind of investment purchases in the US. So it's not required that you make your investment in the United States, but it certainly does help. And officers will sometimes ask about this. The government may also want to see higher investment amounts. So anything you can do to make your case stronger, to show that you have invested the substantial amount will be helpful. Also hiring of U.S. citizens. So in the previous administration, they had a Buy American, Hire American executive order. This time around, the executive orders have kind of different names, but similar ideas around prioritizing U.S. citizens, prioritizing kind of the United States and investment in the United States. So showing you're going to hire U.S. workers, showing you're going to invest in the U.S., these are going to be positive for your case. Really want to focus on hiring employees rather than contractors. So 1099 contractors will not really be considered as strong. Sometimes you can make this argument if you're like in the construction industry and you're paying hundreds of thousands of dollars to contractors. You can often make that argument successfully, but you should still have some employees. And for most businesses, that's going to be much stronger than contractors. Um, Administrative processing. This is something we have started to see more and more, and unfortunately will likely continue. We are in an era of kind of enhanced vetting, and all visa applications the government is asking, for extreme vetting on all of them. So that means that your case, when you go, may not be approved right away. It might be put into administrative processing. Additional security checks will be carried out. And until those security checks are finished, the consulate really can't move the case forward. So you do want to anticipate, that could be an issue, particularly if you've ever had any criminal issues or immigration violations in the past. More USCIS filings. So because of these issues I just talked about, some people are more reluctant to leave the United States. And so may be more interested in filing in the US if they have that ability to do so. One thing that we're seeing that's going to be very important is really trying as much as possible to maintain an underlying status while you wait for an approval to come through. You don't want to be here without that underlying status if you can avoid it. Also longer waits at consulate. So we are seeing kind of cuts across the board. And, these staffing changes could impact, the consulates. Additionally, certain things that were helping to streamline the process, like interview waivers, there are now, greatly curtailed the ability to have interview waivers, even, very kind of long-standing interview waivers. Policies regarding kind of older applicants and very young applicants have now been changed, and this is going to lead to longer wait times because more people will have to go in for interviews.
All right, so thank you so much, Kelly, for sharing all that helpful insight. Let's look at the questions. We're not going to go into the very nitty-gritty facts, but I guess we'll just quickly go through, the general questions here. So, can I have a 50%, 30% U.S. business partner and qualify for the E-2 visa with a partnership? Yeah, that could work. Just make sure that you have at least 50% of ownership, because if any shares held by the U.S. Partner doesn't count towards treaty country nationality, so you do need to have at least 50%. Can my business partner start working for our business before I get the approval? That's usually fine. But make sure that you also meet the investment requirement in the right way, right? So if you're setting up a new business, you want to make sure that your money is going into the business and purchasing the things that are required, or if it's a purchase situation, the purchase has been completed before you apply for the visa. How long does it take for getting the US visa? It really depends on the consulate by consulate. If you're going for an E-2 visa, I would say definitely budget at least several months to get an interview, but it really depends on what consulate you're applying for. Reach out to us if you'd like more specific guidance on a particular consulate. Types of business like trash cleaning, pressure washing, roofing. Really, there's no limitation on the type of business that you can do with an E-2 visa, as long as you meet all of the requirements for the E-2 eligibility as we described in the presentation. Kelly, do you want to take the rest?
Sorry, for which one?
Just, how much investment usually is needed for, Florida state. There is really we spoke about the substantiality requirement. There is no state by state requirement for an investment as long as you meet the substantiality requirement as we described in the presentation. Yeah, and maybe the rest.
Yeah, I think that covers it. It's really just going to depend on the type of business. We can't kind of give numbers. It's
Right,
going to, vary by case. Yeah.
right. Okay. Can you add business consultation and mentoring fee, business credit, personal credit service, legal services, website, monthly fees? And yeah, definitely reach out to us for a consultation if you'd like more specific advice on what type of expenses are usually included in the investment. We did go into detail about the general types that we include. Do E2 investor need to show anything from their business partner to apply for an E2 application? With regards to the ownership, we do want to show who owns the enterprise, basically, proof of ownership of the enterprise because it's relevant to the nationality requirement. Um, but yeah, if you have any particular concerns, reach
Yeah,
out to us for a consultation. Yeah.
yeah, it will depend more on kind of if they're making an investment. So sometimes yes, sometimes no. It's more kind
Right,
of fact specific.
right. Can an Indian or Chinese national get Grenada citizenship to apply for an E2 entrepreneur visa to do business in the United States? So yeah, if Grenada is a treaty country, and if you have Grenada citizenship, and I think there may also be some residency requirements depending on which country you're doing this with. So this may require a little bit more research.
Yeah, it's gotten more complicated. There are kind of requirements now related to people who are getting, citizenship through investment. So that would be something to set up a consultation and discuss your particular situation.
Right. E2 startup investment around 150K. What about the EB5 green card? Yeah, so an E2 to EB5 definitely can be an option for a long-term strategy. Definitely, though, set up a consultation with us to look at the EB5 requirements because the source of funds requirements for an EB5 is a lot more stringent than what is required for an E2 visa. So you want to make sure that the money that you're putting in can actually qualify towards an EB5. And it is an option for someone to qualify for an EB5 based on a company that they themselves set up. But yeah, there are much more specific considerations to think about in advance if that is your long-term goal. Legal costs. Um, I'm not sure what this question is about.
Yeah, if it's about our legal fees, you would just reach out to us separately by email to get those. Yeah, I think I'm not sure what else it's asking, but yeah.
Yeah, so UK nationals, you should uh, you should apply in London in most cases because there is that residency requirement. You do need to show that you've been living in the in the UK for several months before you can apply for the visa. So this may be difficult to apply for somewhere else. Uh, yeah, I think we have answered all of the questions. Thank you so much, everyone, for your participation, and thank you, Kelly, for sharing your expertise. And I hope everyone has a good day. Thank you so much.
Thank you.